When a defense counsel fails to request a jury charge that could theoretically apply, does that constitute ineffective assistance of counsel? To find out, you have to read People versus Debellis, but it's 25 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is the episode on the case of People versus Debellis. This is going to be a challenge. This is a hard case to do in 5 minutes or less. The citation here is 2023 New York Slip Opinion 05964, published by the Court of Appeals on November 21st of 2023. The issue in this case is whether it's effective assistance of counsel or ineffective assistance of counsel when a defense counsel fails to request the only charge that could theoretically be supported by the trial testimony. The law you have to understand to appreciate this case is that there's a Sixth Amendment to the United States Constitution. It's part of the Bill of Rights. It guarantees many rights to criminal defendants, including the right to effective counsel, to the assistance of counsel. There's two kinds of, there are claims for ineffective assistance of counsel, which is basically a claim that you were deprived of your constitutional right to counsel. And there's two standards. There's a federal standard and the New York standard. The federal standard says that a counsel is ineffective if the attorney committed errors so egregious that it did not function as counsel under the United States Constitution, and also that the deficient performance actually prejudiced the defendant. The New York claim, on the other hand, says that a counsel is effective if viewing everything in the totality, viewing the evidence, the law, and the circumstances in the totality, the attorney provided meaningful representation. So New York, the test is meaningful representation, which is more protection than the federal system because it does not require a reasonable probability of, or probability of a different outcome, whereas the federal standard does. The other important part here is that there's a presumption involved in an ineffective assistance of counsel claim. The presumption is that the counsel, the lawyer, acted strategically, that there was a reason for the action they took. They don't want armchair quarterbacking, Monday morning quarterbacking saying, well, you should have done this and you could have done that. There's a presumption built into the analysis here that the lawyer had a reason for doing what the lawyer did. And the other thing you have to understand here is that when assessing whether a jury charge is appropriate to be given on a given criminal case, the test is the court has to view the evidence in the light most favorable to the defendant and give the charge if it's supported by a reasonable view of the evidence. Okay. So reasonable view of the evidence. So what are the facts here? The facts are very complicated, but basically I'm going to boil it down to this. The defendant had a gun illegally for over a year. Sort of not disputed. He had a gun. He shouldn't have had it. He was previously convicted of having a gun, so he knew he shouldn't have had it. He had an order of protection that he said he couldn't have a gun, but he had a gun for over a year. On the day in question, he got into a fight with his wife, got into an argument with his wife about money, according to him. And he then took the gun from his house, from his safe, and traveled 50 miles with it until he was pulled over in the Bronx on a street, driving his friend's unregistered car or expired registration car. And when they pulled him over, the police pulled him over, they said, "Can I have a license and registration?" He said, "I don't have it." But when he reached into his pocket, they saw he had a magazine for a gun. So they say, "Hey, do you have any weapons you shouldn't have?" He says, "No, I do not." They say, "Is there any?" They pull him out of the car. They say, "Any weapons in your car?" He says, "No." He gives a fake name to the police. They search the car. They don't find anything. They search him. They don't find anything. So they say, "We're going to have to tow your car back to the police precinct." And he says, "Well, before you do that, can I get my phone charger out of the car?" And they say, "Okay, we've searched it. It's okay." And when he goes in the car to try and get the charger, he doesn't reach where the charger is. He reaches under the front seat, and they see that and they pull him out and they look where he was just reaching and they find a loaded firearm. He's charged with criminal possession of a weapon in the second degree, a C violent felony. All right. It's a felony. And he then goes to trial. And at trial, he testifies about everything I just said. He says, but his testimony and the evidence put forward is, I was going to return this gun. I was on my way to the police precinct to go do a gun buyback where I can give the gun to the police and they give me money for the gun, which is a defense. There's actually a charge. There's actually a law that says you can surrender a gun. If you're surrendering the gun to the police, then you can't be charged with having the gun because it's sort of an immunity. It's a privileged possession to give it to the police if you surrender it. But when they get to the jury charge at the end, the defense counsel doesn't ask for that charge. He says, I want the charge on temporary and lawful possession, which is a charge that applies if a person basically finds a gun on the gutter and then immediately goes to return it to the police or, get rid of it in an appropriate way. But that charge, the temporary and lawful possession, only applies if it's immediate. Like you can't have it overnight. You can't have it for a few hours. That if you have it for a few hours, you don't get the charge because it's not temporary. A big part of the temporary and lawful possession is temporary. And when the defense counsel asks for the temporary and lawful possession, the judge says, no, I'm the gatekeeper. He doesn't say that, but the essence of it is, as the gatekeeper, the judge gets to decide, is there a reasonable view of the evidence, viewing it in the light most favorable to the defendant, where he would get that charge? And the answer to that question is no, because as a matter of law, he didn't have it temporarily. He had it for over a year. So it's not temporary lawful possession. At that point, the defense counsel does not request the charge on the gun buyback, even though the defendant testified on the stand, I was going to return the gun at the police precinct. We don't know why he doesn't request it. Okay. And here's the thing. The defendant then is convicted. He appeals and says, my lawyer was ineffective because he didn't request that charge. And the oral arguments here are fascinating. And the oral arguments, you should watch them. I'm linking to them in the description. But basically they go through whether he would get the charge if he requested it. And the concept is when the police asked him, do you have any weapons? Right? If his concept is, I'm going to the police to return the gun for a buyback. When the first time he sees the police, they pull him over. He doesn't say, yeah, I have a gun. I'm on my way to the police precinct. He says, no, I don't have a gun. He lies about having it on him. He lies about having it in the car. He basically, it's not clear whether he would get it anyway. And perhaps that's why the lawyer didn't ask for it, but he never requested it. That's the point here. And so there's a 4-3 decision here, a majority, and the majority says he was ineffective assistance because he didn't ask for that charge. Basically they say that him having testified, I was going to return the gun, entitles him to the charge. They even say in the testimony, in the decision here, the Court of Appeals says he would have been entitled to a jury charge on the defense of voluntary surrender if requested by counsel. They make a point of saying, well, I'm not saying it's a good argument. We're not saying that he would be acquitted for it, but he was entitled to get that charge before the jury. And because he didn't, he was given ineffective assistance of counsel who didn't even ask for it. But the dissent is really interesting because they say the test is not, it's not asking for any charge in the whole world. The test is, it should be, is there a reasonable view of the evidence that would allow the charge? Like you're basically sidestepping the fact that when the police asked him if he had a gun, he lied and said he didn't have a gun. So because there's no reasonable view of the evidence, there's no reason to require a lawyer to ask for a charge that he shouldn't get. And this is a charge he shouldn't get because when the police asked if he had a gun, he said no. He never surrendered the gun. So because there's no reasonable view of the evidence, the dissent would say he shouldn't have asked for it. He didn't have to ask for it because he wouldn't have gotten it anyway. But importantly, the majority opinion here is he should have asked for it. And even beyond that, they say he should have gotten it had he asked for it. And that's the case of People versus Debellis. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.